Okay. Hello, everyone. I'm Judge Brewer. We're on the record for case number 2022 CA 1128, Joseph Petito and Nicole Schmidt versus Christopher Laundrie and Roberta Laundrie. And we are noticed for today on plaintiff's motion for leave to file a second amended complaint that appears on the docket at number 60. And would counsel please introduce themselves?
Good morning, Your Honor. Patrick Riley for Joseph Petito and Nicole Schmidt.
Hi, Mr. Riley.
Good morning.
Good morning, Your Honor. Matt Luca on behalf of the defendants, Christopher and Roberta Laundrie.
It's Luca?
Luca, L-U-K-A, yes,
Okay,
ma'am.
thank you so much. Nice to meet you both.
Nice to meet you.
All right, and Mr. Riley, your clients filed the motion, so I'm going to let you get us started off.
Thank you, Your Honor. I'll actually be brief because I think I'll then defer to counsel and I'd like to respond to what he argues. I mean, as the court knows, Florida allows very liberal amendments to pleadings, and the cases say the court should err in favor of allowing the pleading. I'll address all my responses to Mr. Luca, if it's all right with your court, with Your Honor, after he makes his argument. But I think the cause of action, we're simply moving to add another party.
Okay. Sir, if you'd like to respond.
Thank you, Your Honor. And we certainly don't disagree with Mr. Riley that Florida does have a liberal amendment policy. That's certainly the case. However, that policy is not absolute and that the plaintiffs are always entitled to amend. In this case, they want to add the defendant's attorney, Stephen Bertolino. He's an attorney in New York, and he represented them throughout the investigation that preceded this litigation. Your Honor, there's three factors that the court can consider in determining whether to allow a plaintiff to amend. One is whether the privilege to amend has been abused. The second is whether the amendment is futile. And the third is whether there's prejudice to the defendants. With regard to whether the privilege has been abused, now we're certainly not asserting that the plaintiffs have filed too many complaints or they've unreasonably amended in the past. Our position is that they unreasonably delayed in filing this request to amend. The deadline to file amendments and to add parties was August 26, 2022. The plaintiffs waited about 3 months to file the instant motion for leave to amend. And the plaintiffs have had everything that they needed to amend since the inception of this case. Essentially, the crux of this case is based upon a statement by attorney Stephen Bertolino that appeared in the original complaint. And that statement was a focus of the parties' arguments at the hearing on the motion to dismiss, which was several months ago. Nothing has changed, and in fact, at the hearing on the motion to dismiss, plaintiffs' counsel commented that the only reason that Mr. Bertolino is not a defendant is because he lives in New York. And that fact certainly hasn't changed either. So this really isn't a situation where new facts have come to light during discovery or that Mr. Bertolino was unknown or his statement was unknown. The plaintiffs had everything they needed to amend prior to the deadline for amendments. Now the defendants recognize that this case hasn't reached the summary judgment stage or the trial stage at this point, and that discovery is still ongoing. So it's not as though there's some insurmountable time crunch that the parties have to deal with. Nonetheless, the defendants should be able to rely upon the deadlines that the court set, particularly for something as important as adding a defendant who is also their attorney. Now, Your Honor, turning to the factor as to whether or not the amendment would be futile. The plaintiffs here have alleged an intentional tort. And that's important because the plaintiffs have alleged that Mr. Bertolino's liability rests on the fact that he was acting as the agent for the Laundries, as their attorney. But they have also alleged that each of the three defendants, including Mr. Bertolino, acted willfully and maliciously in making the statement. Now, that's not surprising because a cause of action for intentional infliction of emotional distress does require a deliberate act, deliberately inflicting emotional distress. And in fact, it's not even enough that a defendant acted with an intent which is tortious or even criminal. or that a defendant intended to inflict emotional distress, or even that the defendant's conduct can be characterized by malice or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. Rather, liability is established only where the alleged conduct is so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. Now, the plaintiff's amendment claims that the Laundries individually and Mr. Bertolino individually acted with this heightened mental state. If, as the amended complaint alleges, Mr. Bertolino was simply acting as the agent of the Laundries and doing what they instructed him to do, then he certainly wouldn't have this mental state. That seemed to be the position that the plaintiffs took at the motion to dismiss. On the flip side, if Mr. Bertolino did have this heightened mental state, and the Laundries were relying upon his advice as their attorney in issuing this statement, then they could not have had this heightened mental state. Mr. Bertolino would have stepped outside his role as an attorney, so the Laundries couldn't be liable in that circumstance. At the hearing on the motion to dismiss, the court found that Mr. Bertolino's knowledge and intent were essentially irrelevant because he was acting as their agent when he made the statement. If Mr. Bertolino is a defendant and he's alleged to have acted with that heightened mental state, then that changes the equation quite a bit with regard to the liability of all the parties. Of course, we don't agree with the plaintiffs that Mr. Bertolino's statement was outrageous, and our position is that neither the Laundries nor Mr. Bertolino had the intent to inflict emotional distress. But even if we assume for the sake of argument that the statement was outrageous, it's implausible that all three of the defendants would have had that heightened mental state given their respective roles with regard to issuing that statement. This is not a case where there's alleged to be a conspiracy or some collusion in some way for them to issue this statement with an intent to inflict emotional distress. Your Honor, also with regard to the futility argument, we've raised Florida's litigation privilege. Now, the litigation privilege affords absolute immunity to statements that are made during a judicial proceeding. In Fritovich versus Fritovich, the Florida Supreme Court recognized a qualified immunity for statements made to police in a pre-indictment context. So the Florida Supreme Court has extended the litigation privilege outside of the litigation context to include other statements if they're sufficiently connected. There are a couple other cases that we cited in our brief. Ainge, which was with regard to statements made to a judge during the search warrant context and obtaining a search warrant. Robertson, which were statements made to the insurance commissioner. And Delmonico, which were statements made during an informal investigation while litigation was pending. It's our position that Mr. Bertolino's statement was made in response to requests from law enforcement for comment. So our position is that the litigation privilege would cover it, even a qualified privilege. I'd also like to point out that ABA Model Rule of Professional Responsibility 3.6 subsection C provides that a lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. Keep in mind that at the time of this statement, Mr. Bertolino was also representing Brian Laundrie, who was unquestionably under investigation for murder, and that there was an incredible amount of media attention. So we would assert that if Mr. Bertolino is permitted by the rules of professional conduct to make such a statement, then the litigation privilege should extend to such a statement and shield it from litigation. Lastly, Your Honor, with regard to the prejudice to the Laundries, Mr. Bertolino has been their attorney since the inception of this investigation. He's still their attorney, and he owes them all the duties that an attorney would normally owe to a client, including communication, confidentiality, loyalty, and such. And if he's a co-defendant, he can't fulfill those duties. This is not a more typical situation, as the plaintiffs asserted in their brief, where an attorney and a client are sued together because they're alleged to have conspired in some way, to commit a crime or some other act. And in fact, you know, their communications in such a context wouldn't even be protected because the crime fraud exception to the attorney-client privilege would effectively do away with any protection. This is a novel situation where an attorney's rather benign statement is alleged to have been made with the intent to harm the family of the victim of a crime that was not committed by these defendants. So it is a very, very unique and novel situation that the plaintiffs are trying to bring here. It also can't be ignored that Mr. Bertolino's representation of Brian Laundrie put him in a position to have far superior knowledge of the facts and circumstances of what occurred than the defendants in this case, the Laundrie parents. That certainly it can't go unnoticed. You know, essentially adding Mr. Bertolino here as a defendant puts the attorney-client privilege and Mr. Bertolino's other duties to the defendants squarely at issue. Not just his duties to the Laundrie parents, who are the defendants in this case, but also his duties to Brian Laundrie. Even though Brian Laundrie is deceased, the attorney-client privilege with respect to his statement survives. Now, Your Honor, if Mr. Bertolino were added as a defendant here, both he and the Laundries would have an interest in defending themselves. And that defense could potentially be to the detriment of each other, depending on what positions they were to take in the litigation. And plaintiffs effectively want to invade the attorney-client privilege by putting Mr. Bertolino in an untenable position where he would want to defend himself and potentially use attorney-client privilege information, but he can't. And on the flip side, my clients may not want to use that attorney-client privilege, but they're put in a position where they would have to waive that attorney-client privilege just so Mr. Bertolino could defend himself, just so he could present a defense. Otherwise, they'd be in a situation where essentially they would have a co-defendant sitting at the table who couldn't speak, who couldn't defend himself. It would be an incredible, awkward, and odd trial if that were the case. The attorney-client privilege is a foundational principle in our legal system. Enforcing a conflict over that privilege by adding Mr. Bertolino as a defendant would violate the public policy behind that privilege. As stated before, plaintiffs allege Mr. Bertolino is only liable because he was acting as the agent of the Laundries, acting as their attorney. If he didn't personally have the intent to intentionally do harm, then he shouldn't be a defendant. The Laundries should be able to defend this case without worrying whether their attorney is going to take a position that is antagonistic to them or that somehow they wouldn't have the full, they wouldn't be able to avail themselves of all the duties that Mr. Bertolino owes them because of his situation as a co-defendant. Thank you, Your Honor.
Okay. Mr. Riley?
Thank you, Your Honor. May it please the court. I kind of felt like I was listening to an argument on a motion to dismiss, not on a motion as to whether or not a complaint should be amended. And it sounded more to me like Mr. Luca was representing Mr. Bertolino than he is representing the Laundries. I think none of that has any relevance to what's before the court today. Again, as I said, it's the public policy of the courts in Florida to freely allow amendments, except in 3 instances, as counsel pointed out. And I'll address whether or not the privilege has first been abused. Counsel didn't argue that the privilege has been abused. He simply said we're beyond the date where the deadline was set to file an amendment to the complaint or to amend the pleadings. It's important to note that the pleadings in this case weren't actually closed until, I believe it was July 15th of 2022 when the answer to the complaint was filed, and the deadline to file an amended complaint was, I believe, in August. So the pleadings were just barely closed at the time that deadline came up. And maybe we should have filed earlier to join him, but I don't think the fact that a deadline to file a pleading, an amendment to the pleading came and passed is abuse when you're considering whether or not to allow the amended complaint to be filed. We could file a complaint against Mr. Bertolino separately and then asked to have the matters joined for purposes of trial and for discovery. So I don't see how that there has been an abuse by the failure at this point in time, or up until now, to request that he be joined. There's been no depositions. There's been minimal paper discovery that has been exchanged. A part of the problem in this case is there was a FOIA request filed with the federal government back in the summer of 22, I believe it was, or maybe even earlier. And we've been waiting for that information, and we still don't have it. So discovery really can't move forward in terms of depositions until we have that information. So there's really no delay being caused by the filing of this motion. Secondly, addressing the issue of whether or not the amendment would be futile, the courts have held that proposed amendments are futile when they are not pled with sufficient particularity or are insufficient as a matter of law. And I cited the court to the case of Thompson versus Bank of New York, which affirmed the trial court's denial of a motion to amend because the allegations of fraud were conclusory and lacking in any real allegations of ultimate fact showing fraud, such that the proposed amendment the amended pleading was insufficient as a matter of law. Counsel hasn't suggested in this instance that the amended complaint hasn't been pled with sufficient particularity or is insufficient as a matter of law. Florida courts have held a futility of an amendment when it conclusively appears there's no possible way to amend it to state a cause of action. What I think is critical is futility should be analyzed based upon the face of the proposed amendments, amended pleadings, and that's the case of JBJ Investments of South Florida Inc. versus Southern Title Group, 251 Southern 3rd, 173. Additionally, any doubt with respect to futility should be resolved in favor of allowing the amendment, especially when leave to amend is sought at or before the summary judgment stage. And that's the case of RV-7 Property Inc. versus Defani De Leo Inc., 187 Southern 3rd, 915. As I said just a minute ago, the defendants don't suggest that the amended complaint is insufficient as a matter of law because the Second Amendment contains any conclusory allegations or lacks any real allegations of ultimate fact supporting the cause of action. In fact, Judge Carroll has already found that based on these exact same pleadings, the motion to dismiss was defeated, that the case was sufficient to move forward on these very facts. So we're not addressing these facts again because the court's already ruled that it's sufficient. What we're addressing is whether or not a new party should be added based on those facts. Interestingly, the defendants instead focus upon alleged defenses that perhaps Attorney Bertolino could raise. I would submit that's not sufficient to show that this complaint is insufficient as a matter of law. But even if it is appropriate to address those issues at this point in time, which I don't believe it is because they are defenses to be raised, not something to show that the amendment would be futile, the defendants first suggest that if, and it's their words, if Stephen Bertolino committed an intentional tort for his own purposes and not on behalf of his clients, then his clients cannot be liable for the act of their agent, and the Laundries should be dismissed. But the dismissal of the Laundries is not, again, an issue in this case. This is not a motion to dismiss. As counsel indicated, generally an attorney is an agent for his client, and the acts of the agent are the acts of the principal. In a principal-agent situation, the principal is liable, in this case the Laundries, if the wrongful act is done while the agent, Mr. Bertolino, is acting within the scope of his apparent authority, even though the act was not authorized by or was forbidden by the employer or was not necessary or appropriate to serve the interest of the employer, unless the act was done to accomplish his own purposes as distinct from the employer's business. Again, we have to look at the face of the complaint. What does the face of the complaint say about what Mr. Bertolino was doing at the time he made the statement? Paragraph 8 says that at all times relevant to the cause of action, Stephen Bertolino was acting as the agent for Christopher Laundrie and Roberta Laundrie. Paragraph 28 states that Stephen Bertolino was acting on behalf of Christopher Laundrie and Roberta Laundrie when he issued the statement which is the substance of the claim for intentional infliction of emotional distress. We haven't alleged that he was acting outside of the scope of his authority when he made the statement. The complaint clearly states he was acting on behalf of the Laundries at the time he made the statement. So the principals are liable, the Laundries are liable in this instance, as is the agent, because an agent is individually liable to a third person for the agent's tortious conduct. And I cited the court to Sussman versus First Financial Title Company of Florida at 793 Southern 2nd, 1066. I'd also like to cite the court to the third restatement of agency, section 701, which says, an agent is subject to liability to a third party harmed by the agent's tortious conduct. Unless an applicable statute provides otherwise, an actor remains subject to liability although the actor acts as an agent or an employee with actual or apparent authority or within the scope of employment. To suggest that the claim can only be made against the Laundries or on one hand, or against Mr. Bertolino on the other hand, is simply incorrect. It's entirely appropriate and it's entirely proper to set forth a claim against both of them under circumstances such as this. The defendants then suggest, again, really an issue for a defense, not an argument on whether or not we should be permitted to amend. They suggest that Mr. Bertolino is afforded immunity under the litigation privilege. While this may be posed by Mr. Bertolino as a defense, it's certainly not the subject of whether or not it's appropriate to file a motion or to grant a motion to amend. I would also cite the court to a case, and I apologize for not providing this previously. But this is the case of the University of South Florida Board of Trustees versus Moore. It's a September 30, 2022 case at 347 Southern 3rd, 545. In that instance, the issue was whether or not there was immunity, sovereign immunity provided to agencies of the state. The same argument would apply here where the court ruled, when ruling on a motion to dismiss, and I understand this isn't a motion to dismiss, but there's an analogy. When ruling on a motion to dismiss based on sovereign immunity, courts are required to treat as true the complainant's allegations, including those that incorporate attachments, and to look no further than the amended complaint and its attachments. A motion to dismiss is not a substitute for a motion for a summary judgment, and in ruling on a motion to dismiss a complaint, the trial court is confined to consideration of the allegations found within the four corners of the complaint. Counsel has suggested that Mr. Bertolino has a defense to this case, and therefore we should not allow the amendment to take place because it would be futile. But even if the court allows this to go forward, Mr. Bertolino cannot allege in a motion to dismiss that he has immunity, because the court says you just look at the four corners of the complaint. So to suggest that he has these defenses doesn't mean that filing the amended complaint at this point would be futile. It simply means that at some point after the pleadings are closed, he may have an opportunity to address those defenses if they are applicable. Defendant also suggests that's the statements made in the course of a judicial proceeding. I'm going to address that issue even though I don't believe it's appropriate to be raised at this point, but correctly suggests that statements made in the course of judicial proceedings are absolutely privileged no matter how false or malicious the statements may be, so long as the statements are relevant to the subject of the inquiry. There's two problems with their argument. First, as they stated in their motion, we cannot know for certain what proceedings such as grand jury proceedings, search warrant applications, or other judicially supervised investigative proceedings had been underway at the time Mr. Bertolino made the statement, because those investigative proceedings are done ex parte and are not disclosed publicly. Well, if the defendant can't tell us what they are, how can the court say, well, there was a proceeding pending and therefore Mr. Bertolino's statements would be protected? Secondly, without knowing what those proceedings are, how could the court determine if the statements were relevant to the subject of the proceeding? So I think that argument, although it shouldn't be made here, fails, and I don't think that the defendants have presented anything to show that allowing the amendment in this case would be futile. The third issue which is addressed, again, is one that's really interesting about the prejudice to Mr. Bertolino. A lot of the argument was about Mr. Bertolino and to the Laundries in this particular case. The court has said in Morgan versus Bank of New York Mellon, 200 Southern 2nd 792, a Florida 1st DCA 2016 case, whether granting the proposed amendment would prejudice the opposing party is analyzed primarily in the context of the opposing party's ability to prepare for the new allegations or defenses prior to trial. The defendants themselves, in their opposition to this motion, have stated, the proposed amendment adds some additional jurisdictional allegations related to Mr. Bertolino, but by and large, the proposed amendment does not change the cause of action or the foundational factual allegations supporting that cause of action. And in fact, there are no new allegations addressed to the defendants in this case. It's simply adding another defendant to the case. So the defendants have not cited this court to any case to support their position with regard to how difficult it will be for the defendants to defend themselves, whether the attorney-client privilege will be violated, and all of those other issues raised by them. They've not provided one case to support their argument that that's grounds not to allow the filing of an amended complaint. I would go back to the case that I just cited, Morgan, where there is no prejudice to the defendant because of their ability to prepare for new allegations or defenses prior to trial, because there are none. So in conclusion, I would argue they failed to establish that the right to file an amended complaint has been abused. They failed to establish that it would be futile to, if the amended complaint is allowed to be filed, and they failed to establish prejudice to the parties. It doesn't matter whether there's prejudice to Mr. Bertolino at this point. He's not a party. They failed to establish that there's prejudice to the Laundries in allowing the filing of the amended complaint. Thank you.
Thank you so much. I have reviewed the, first off, I have reviewed the court file in total for this case, and as well specifically as Judge Carroll, as to Judge Carroll's order denying the defendant's motion to dismiss, and the instant motion, as well as defendant's response and plaintiff's reply to defendant's response. I've heard the arguments, and at this time I am going to be granting the motion for leave to amend. I find that the plaintiffs have not abused the privilege of amendment, that the amendment at this juncture is not futile, and there is no prejudice to the current defendants as to their preparation for trial or summary judgment. So I will be granting the motion for leave to amend. There was a complaint attached. We can deem that to be filed as of today or as of the date of the order, whichever one you should so choose. It's up to both of you.
It doesn't matter to me, Your Honor. Whatever you decide is
Your
fine.
Honor, we have no preference either. I
Okay.
guess the only difference it might make is just the amount of time we have to respond.
Okay, let's do it. Let's do it as of today then. And how much time? Well, you're not representing Mr. Bertolino.
I am not.
And
No,
you
Your Honor.
haven't gotten him served,
No.
obviously. So, with that being said, we'll just do standard time pursuant to Florida Rules of Civil Procedure. And then if any amendments need to be made to your responses, then obviously you'll get the appropriate amount of time to, when I say you and your clients, Mr. Luca, you'll be able to do that. Anything, with that being said, and this may be a tick premature, but I know that you guys are set for trial for August. That's my understanding.
That's correct.
Does anybody believe that that's going to happen?
You know, Your Honor, I was actually going to talk to Mr. Riley about this, maybe after this hearing. Just based upon how long it's taking to get a response to this FOIA request, and I understand that this is important information.
That's on me to review.
And I think
Right.
we both, Mr. Riley and I, would like to see what he gets back there. So, it may be a situation where we are going to need to move to extend all of the deadlines if it just kind of continues to drag on.
The latest information we have is that we'll have it by the end of this month. But we've heard that before.
Okay. So we can pause this discussion until maybe we kind of get together for a case management or something to kind of see where we are. I don't want you all to be on the August calendar thinking that we're gonna be going and then it not happen. I'd rather us know in advance that it's not going to, especially adding in a new party. I'm assuming that Mr. Bertolino is going to defend the action. He's here with us today on Zoom. So with that being said, we'll probably want to set a case management sooner rather than later. You're
I agree.
expecting when is the expectation for the FOIA request again?
Within the next week. We're told by the end of the month.
Okay, so if the two of you would contact my judicial assistant, and let's maybe schedule some time for a case management coming up here in the next month or so, just so
Okay.
that I have a good idea and we can kind of have it structured going forward and what we're thinking time-wise.
Can we do an early March, Judge? Give us time to serve Mr. Bertolino and then.
That's absolutely fine with me.
Okay.
When I said, I mean, it's January 24th now, so.
Yes.
Within the next month, early March and into February is about the same thing, isn't it?
I'll assume responsibility. I'll assume responsibility for getting that scheduled.
Very good. And would you provide me a proposed order, Mr. Riley, after running that by your opposing counsel and send that through the portal?
I will do that, Your Honor.
All right. Anything else that we need to cover today?
No?
No, I don't think so. Thank you for your
All
time,
right.
Your Honor.
Thank you all so much. I appreciate it. Y'all have a great rest of your day.
Thank you, you too. Matt, I had that very conversation with them earlier.
Okay.
Mr. Riley,
Yeah.
Yes, Your Honor.
you provided 2 notebooks. I don't know if the other one was supposed to go to somebody else.
I don't know
or-
why I did that.
I'm going to give you back your other notebook, 'cause
Thanks. I'm saying thanks, but now I have to carry it.